Hi, everybody. Welcome to another episode of the That Depends podcast. Today, we're joined by Thulasi Raj. Thulasi is one of the advocates for an intervener in the contentious Karnataka hijab hearings that are currently ongoing. We get her thoughts on the arguments of the petitioner, the government order that led to the entire controversy, and this is also one of the first cases or high profile constitutional cases that is being live streamed on YouTube. So, we get her thoughts on that issue as well. Hi, Tulsi. Thanks so much for joining us. And before we get started about the arguments of this case, could you just give us a brief background as to how this controversy developed? Because we are now in February of 2022 and it started almost 2 months ago. So if you could just walk us through what's happened in the last 2 months.
Right. Thanks. Yeah. First of all, thanks a lot for the invitation. It's always great to talk constitutional law, especially with people who are interested in and thinking about constitutional law. So, of course, the hijab ban started a couple of months ago when the pre-university college expressly banned hijab. It was a case where they just said that Muslim students were wearing the hijab simply cannot wear it, and that from there it started. That was the first instance of the hijab ban, and from there several institutions started gradually emulating this and started telling Muslim students not to wear it. And Muslim teachers also faced in some institutions certain hostility for wearing the hijab, and that is how the government. That's the context of the government order. The government issued the GO saying that religious symbols cannot be worn, whichever religious symbols or clothes are, which are against public tranquility or public order. So and then there were cases filed both by students challenging the ban in respective institutions, and cases were filed challenging this government order, the validity of this government order, and saying that the government order should be in fact struck down for a lot of reasons, including the right to religion and discrimination grounds. So that is the brief context of the current hearings in the Karnataka High Court.
Yeah. And I guess some useful context for people who are not from Karnataka also is that pre-university colleges are basically grade 11 and grade 12. Am I correct? Yeah. So we're really talking about students who are between the ages of 15 and 18. Um,
One more thing just to flag it is that the government order, so that's what how I've understood, is that the government order basically says all religious symbols that students wear, which is not prescribed in the uniform, should not be allowed. And from that line, what has happened is that universities or pre-universities have started banning students wearing hijab. So that's the thing, because at one level the GO says that only all religious symbols should not be allowed, but the impact it has is only on hijab, and that's why this whole challenge and this whole High Court hearing is based on an angle that this is actually impacting Muslim students. And from there, what the first argument, that's the overarching argument that's been argued in this case, is that wearing a hijab is essential to my religion, and it is what something we call as an essential religion practice. Therefore, it cannot be stopped. So I think just to discuss, firstly, what is this essential religious practice and why is this being the line of argument that's been taken by the councils?
Right. So before going into ERP, the reference in the government order is, of course, of headscarves, and it quotes certain judgments and says that these judgments have held that headscarves or head veil are not essential part of the religion. And then it goes on to then say in the operative portion that none of the religious symbols are allowed, which can have a breach on public order. So that is the reference with respect to a particular religion, that is the hijab or the head veil, in whichever way you want to call it. And that is why the government order partly is being attacked, because it does expressly mention the headscarf, although not in the operative portion.
I'd like to jump in here. Could you just tell us, based on your experience as a lawyer dealing with administrative issues, so the government really didn't need to talk about the headscarf or the cases that allegedly say that banning a headscarf is okay. It really didn't need to talk about that, right? This was an order in response to universities who were already banning the headscarf, and the government has come out and said, you know, we don't think it's illegal, right? And then they've said that is sort of in the pretext, and then the operative point, like you said, the operative part of the order says no clothes that violate like equality, unity, and public order. So I was just wondering, is this something that you see often in government orders, and why did the government really do that?
Right. So if you talk about the reasons on which administrative orders must be judicially reviewed and must be set aside by courts, there are of course multiplicity of grounds available to challenge this particular order. Usually in administrative law, we know that there are a lot of grounds that we take, and that is much wider than how legislations are even challenged, because you can take grounds such as non-consideration of relevant facts, that the order is vague, that you cannot make out what it actually means. You can take the ground of non-application of mind, that the decision maker did not really apply her mind while issuing the order. So you can take all these grounds, and I think all these grounds are available to the petitioners in this particular case. And you're right that I don't think that they did need to actually talk about the headscarf. I think they wanted, what the government tried to do with that is that they wanted to bring on some legal sanctity to the order. They wanted to say that, yes, what we are doing has a legal foundation. So even if it's all guesswork, but it looks like what they want to say is that even if you implement this particular order with respect to the hijab, as many institutions are doing currently, that wouldn't be wrong, that wouldn't be illegal, because all these judgments are there in support. And this is how we interpret the judgment. So relying on these judgments, all the institutions which are banning the hijab would be correct in law to do so. And that, I think, simply is the motivation behind inserting those judgments, which are relied on to say that the head veil should be banned. Yeah.
Those judgments were given in different contexts also, right? You can't just say, these judgments say so we are doing so, because you have to understand, like, maybe the facts of that case would have been different. And in this case, the impact is that students are not being allowed to go to classes, and that's the key impact. The thing that because of religion, I'm not being allowed to go to my class, and that's where the whole ERP or essential religious practice things comes in. I think you were trying to explain that. Sorry.
Right. And in fact, there is, as we know, as at least many of us know, there is a Kerala High Court judgment by Justice Muhammad Mustaq that expressly says that wearing the hijab is an essential part of Muslim religion. So it is by ignoring that the whole GO, it looks like, has been passed, or it's not been taken note of, or it's been conveniently ignored. So we have a constitutional court's judgment which has already laid down whether hijab is an essential part of the religion or not, which has been relied on by the petitioners immensely, and obviously so in the current proceedings. Now coming back to the ERP, we know that the ERP has a lot of problems. So ERP, as just to briefly explain what it is, I think most of us are who are following the proceedings and otherwise are aware of what it means. But the essentiality test basically says that whichever practices are essential or integral to the religion are what is protected under Article 25, and it is these practices and these beliefs which the state cannot really intrude on. The state really cannot intervene, and this is the core or the heart of the essentiality test, which was laid down by the Supreme Court in the Shirurmat case in 1954, and has been followed subsequently in various judgments of the Supreme Court and the High Court.
And just to clarify, because if you read Article 25, it doesn't say anything about essential religious practice, right? So this is something that has definitely come from the court, that every time the state has tried to regulate a religious practice, the court has gone into, okay, is this practice essential to the religion? And if it is essential, then okay, maybe the state should back off. And if it isn't essential, okay, maybe the state can regulate it. But that's not the framework that Article 25 itself lays down. So could you just tell us, like, what Article 25 lays down?
Right. Article 25, of course, lays down, in fact, it's broader than simply right to freedom of religion, I would think, because it guarantees the right to freedom of conscience, which also includes to some extent any belief that's based on conscience, such as the belief of an atheist that there is no God, or all those beliefs also come within the ambit. And I think the makers of the Constitution deliberately intended to use those words to give a sort of wider ambit to the right to freedom of religion or belief as it is. And I agree that there is, of course, no test of essentiality laid down in Articles 25 to 28. It's, of course, a judicial invention, and a bad one, because of reasons such as lack of expertise of the courts to go into religious texts and interpret religious, whatever is said by religious leaders. And that itself becomes a very, very bad test for understanding what freedom of conscience is under Article 25. And moreover, the essentiality test becomes even more problematic because it's a very wide test by looking only at what this religion actually holds, or what the beliefs broadly are. It looks at a lot of things, or a lot of elements or aspects are relevant for understanding the essentiality test. It looks at how rigorous the practice is. It looks at how widely it's been practiced. It looks at the historical aspects of how many years or decades it's been since the religion has been holding on to this belief, and all these things which have very little to do with the particular individual who is actually holding the belief or practice. So it removes agency almost completely from the test, which is antithetical to, as we know, the concept of rights as such. All civil and political rights, or rights in general, we always put individuals first. Although we talk about communities, we talk about families, we talk about religion, we talk about association, but rights are, after all, individual centric. And that individual centricity is what is sought to be removed because of the essentiality test, which I think is to a great extent illegitimate, and a legitimate discovery of the Constitutional Court in India.
I think just to circle back, what I sometimes think is that, so this is what I think out of top of my head. I've not really read to think of this, but what I think usually is that this essential religious test maybe at some point has developed over the years to manage or to control the mismanagement of religious institutions. And for example, if you start reading judgments, it's like, who will be head, who will the finances manage? And slowly now when our constitutional discussion is all about individual rights of the individual, then this test, which was actually there for management, is being imposed on the individuals. So I think this is also a conflict, right? Because the individual says, this is what you were saying, that this agency of mind, that this is important for me. But they say, this is not what everybody believes. So then who really decides what is essential religious is, and do courts really decide that? So I think that's one, if you start thinking about it, it's that one roadblock that you find. But so in this case, for example, then how do you think it's being, or like, how is it being argued actually? What is this essential religious thing that's being argued?
So, I mean, you're right on the first bit, I think, because even the Shirur Mutt case, to a great extent, was about management of the mutt and administration, financial aspects, and all of those. And interestingly enough, even Shirur Mutt case, I think the Supreme Court said that the religion is the best judge to decide what the essential practices of the religion are. And it is somewhat ironical that judgment laid out the essentiality test, and from that, and I think, in fact, the judgment said no outsider can determine what the essential practices are, and it looks like the court has conveniently left out itself from the ambit of an outsider and say, yes, of course, nobody else can, but of course we can determine, and we can assess religious beliefs and say whether they are essential or not. And I mean, now onto the second limb of the question, the way the petitioners are arguing the essentiality test is largely based on precedents, and of course based on religious texts like the Quran. And they essentially talk about how the test was. The test is the classic way to determine whether a person has the protection of Article 25 or not. And then they take precedents from Shirur Mutt onwards. Then there is the Acharya Avdhuta case of 94, which also talks about the essentiality test. And they have relied on precedents mostly to say that, and including cases like the Jehovah Witness case, which is in which the students wanted to claim a right to not sing the national anthem. All these cases are being very heavily relied on by the petitioners, and they also rely on religious texts of the Quran, of speeches of religious leaders in Islam, to say that how integral the wearing of the headwear is for Muslims.
So I just wanted to, I was a little bit curious, because this is where I feel like this case got into sort of political hot water, where when you're arguing for the rights of Muslim women to attend an educational institution, you're quoting sections of the Quran that require women to cover up bits of their body. And this is where like everybody, I feel like, sort of started having their little whatever Twitter tirades and like online news debate, I mean whatever TV news debates and stuff like that. And from what you're telling me, it's basically entirely because of this essential religious practice doctrine, which requires the court to determine whether or not Islam requires women to wear the headscarf, right? Um, I'm gonna like pose a hypothetical to you, and you can tell me like how this would have impacted the case. If you had to say two sects within Islam, right? One that required the wearing of the headscarf and one that didn't require the wearing of the headscarf, right? And then the one that required the wearing of the headscarf went to court and said like they're not letting me wear it, right? And now the court can't say essential religious practice because there's this other sect of Islam that doesn't require the headscarf, right? So what we really need is, you need to, I feel like at some point accept that there is some amount of heterogeneity within a religion. And how do you think like a court would have dealt with a situation like that?
So I think that again brings us back to the problem of essentiality test, and I think the way that you've laid out how the court would react, or how sort of two religious sects saying that this is actually essential, or someone saying that this is not essential, has led the courts completely confused with whenever they interpreted religious aspects and beliefs under Article 25. I remember in one of the cases with respect to the question whether the sacrificing of a cow is essential for Bakrid, they were looking at religious doctrines and the aspects and parts from the Quran and saying that what it actually requires is sacrifice of an animal. Therefore, sacrifice of a cow as such is not what is really told by the religion, and hence, that doesn't, sacrificing a cow on the day of Bakrid might not be as essential as is claimed by the petitioner. So that the Supreme Court has said, and this is, in fact, this brings us back to the whole problem with essentiality, that the moment I think even a person or a sect from a community, from a particular community or religion says that I don't do this, or this does not look essential to me, then the court is immediately diluting the test and saying that yes, there is someone now from your own religion who says he or she does not practice this or does not believe it, and hence that itself is sufficient to draw the conclusion that is not essential, which I think is erroneous in itself. But that's what the courts have been doing.
The problem is that, for example, if those two sects of Islam did exist, I could still have a really sincere belief that it's really important to my own religious practice to wear the headscarf. Right now, just because somebody else in my religion doesn't feel that strongly about the headscarf does not necessarily mean that the state should have the right to take away my sincere belief. Right? Like this is the problem that I've been like figuring out with this case.
That I remember, I was following the proceedings, and at one point, this is when ERP is being argued, Justice Dikshit asks the petitioners counsel that, are you trying to argue that everything in Quran is essential to the religion? And then the petitioner was stuck because he didn't know what to answer, because if he answers yes, then it's a problem, because Quran says a lot of things which might not be with people not accepted. But if he says no, then his whole case falls flat. So then he tried to circumvent it through a smart code craft, but everybody who was following saw it, because I think that's what the problem that we're discussing is, that how are we deciding? And that's the belief of the person is actually being put on the side. And so do you think could there have been any other argument that could have taken in this case, or some other way that this case could have been argued, which might not lead to these traps?
Yeah. I mean, on essentiality, of course, as Vasu put it, the problem is precisely that whether or not my argument under Article 25 will succeed or not depends on something else which I cannot control. It depends on historical factors. It depends on whether other people practice it or not. It should ideally depend on how strongly I am attached to that belief or practice. But it's simply not. In ERP and the way the text is conceived, it's just completely out of my control, and I can't do anything about it, even though I genuinely, bona fidely believe that without this practice, my religion wouldn't exist. Even if I think that it's so integral and so closely associated with my religion, that doesn't matter. And that is of course the problem with,
Yeah, and just to close out this discussion, I think it's important to point out that Article 25 acknowledges this and says that there are limits to this, right? That I can't claim that something is my religious practice, and I hold a sincere belief, and then say do something that could actually harm other people, right, or result in my own death. And you have all those cases about, say, consumption of marijuana, or the Tandava cases, where people are doing activities that could disturb other individuals' rights, could disturb public order. And I think the petitioners quoted some of those cases as well, in terms of if you do activities such as human sacrifice. Now you can't say that I have a sincere belief in this human sacrifice and therefore I want to commit human sacrifice. So Article 25 recognizes the limits on it, but it doesn't require that all of the religion needs to believe exactly the same thing about my religion that I do. So I think this is something that the constitution seems to have figured out, but the court seems to have unraveled on its own, right? But I think Rishab's question is the more interesting one, which is, if you had to argue this case slightly differently, how would you choose to go about it?
I think the most straightforward way to go about the case would be to argue on discrimination. You could argue, because these are government colleges, and I think even if it were private colleges, you could build up very easily a case on discrimination relying on Article 15(2). So the classic argument, and in fact the very kind of discrimination that the makers of the Constitution intended to prevent, is precisely this: that you take a protected characteristic under the Constitution, under Article 15, and then you're discriminating precisely based on that. So Muslim women are just being deprived of accessing educational institution, or accessing classrooms, because they wear the hijab, because they have a sincere belief, because they think that wearing hijab is, whether essential or not, they think that it's part of their freedom of conscience. So the most straightforward argument, I think, to go would be a discrimination claim under Articles 14 and 15. And there is also
just to push back a little bit on that, because today the AG came and he argued that the government order actually is a little bit innocuous, in that it just says that the dresses should not violate unity, equality, and breach of peace and public order. Yeah. So could you say that the order itself targets Muslims or targets women?
Right. So in terms of innocuousness, I think, considering the political context, I do not think that it's innocuous at all. I think there is a specific intent of the political right wing to impose and to have a certain kind of narrative, and there are also political reasons as to why that's being done. So I do not think that's anyway, in the sense, the government order and the way it's come forward, and the particular context in which it is being launched, and the way in which it's actually being implemented in various colleges. But to talk about the law, of course, the government order on its face, in the operative portion, does say it's all clothes which are in breach of public order or public tranquility are banned, and of course college administrative authorities would be at liberty to determine whatever uniform they want to prescribe for the institutions. But this is where the concept of indirect discrimination in fact comes. And even if the government order looks neutral, it's neutral on the face of it, it has a worse impact on hijab wearing Muslim girls. Therefore, it would be, in fact, this is the classic case of indirect discrimination, and we usually talk about examples of Sikhs wearing the kirpan, like it happened in a Canadian case called Multan, where the court actually discussed whether there could be a practice banning headgear of all religions, and how far the Sikhs are impacted by this particular practice, and actually held that they were, and that it was a sincere religious belief to wear the kirpan. And so these are the ways in which the government order could be attacked on the basis of Articles 14 and 15. And in terms of what basis the discrimination takes place, I think we have two answers here. There is of course discrimination on the basis of religious identity, namely by being a Muslim. There is of course also discrimination on the basis of sex or gender. For the fact that they are Muslim girls is why they are being discriminated against. So we just take a counterfactual. We know that for Muslim men, this problem wouldn't arise because it's not customary for Muslim men to wear the hijab to begin with. It's also not a problem for non-Muslim women, because non-Muslim women are also not wearing at least the hijab, strictly speaking. Therefore, it's an intersection of two identities. It's the intersection of being a Muslim on the one hand and being a woman on the other. It's when two of these identities interject that you're actually being a victim of discrimination in this case. And thankfully enough, Indian discrimination law has traveled sufficiently advanced, at least in 2022, when we talk about, we have the doctrine of intersectional discrimination, which are laid down in the Navtej case and in a couple of subsequent cases as well, where the apex court made references to intersectional discrimination. We have the doctrine of indirect discrimination as well, which is laid down by Justice Chandrachud in the Colonel Nitisha case. We also have a doctrine of manifest arbitrariness, which is laid down in the Shaira Banu case by Justice Nariman. So we have all tools. We are not lacking any legal tools to actually attack the government order, and the court also, in that way, is not lacking of any tools in discrimination law to say that the government order is bad for either being manifested.
Just to clarify, so you said you have the tools to attack the government order, but could the government not argue that the order itself, because it just says that okay, the colleges uniforms must be followed, right? It's actually the individual colleges themselves that are like at fault here, because for example, if there was a college that allowed the hijab, right, as part of its uniform, the government order says that will also continue, right? So are we looking at situations where we should be like more scrutiny should be placed on the individual college administrators who are passing these orders, or do you think that it's mostly the government that's at fault?
So I think it's the sort of interplay of the political context in Karnataka, broadly speaking, which is somewhat intimidating for Muslims, it looks like in the present context. So it's that political context interacting with the government order and the way it is framed. And I think it would be somewhat less problematic, I think, theoretically, if the government order did not talk about head veil or headscarf at all. Now, the government order does put a context to it. The government order does say that it looks like there is no essential religious practice of wearing the headscarf or the head veil, and that indicates somewhat of an intention to discriminate. And then it says that all clothes which breach public tranquility are banned. So I think you could read a lot from the way the government order is structured, but I think the only part of the fault lies with the government order, of course, and the other part lies with the colleges which are actually going ahead and saying that yes, the wearing of the hijab falls within the ambit of clothes which disturb public tranquility. I think that is also a wrong interpretation, which cannot be allowed to sustain in law. So they are also at fault in that regard.
Yeah, and I think today, so just because we were following the proceedings also, today the Chief Justice also asked the AG, who's the government counsel, saying that, why have you extracted the judgment and why have you written headscarf? Because at one level you are saying this is innocuous in nature, it's just neutral. Then he's like, why have you reproduced these judgments? And the AG just said, it could have been drafted better. So that's not a response, right? That's not a response. So, and the second thing is, because what we're discussing, if it applies to all religions, then it's even worse at some level, because then it just says that no religious symbol can be worn, and that also at some level contradicts everything that the Constitution guarantees, right? Because if the test is of indirect discrimination, think that now all minorities who's actually have to wear certain religious symbols are being impacted, because they really believe that this is essential to the religion. For example, turbans are a religious symbol at the end of the day, so they can be banned, which is also not correct, right? Nobody is saying that it should be banned. Everybody should be allowed to wear the religious symbols. That's the real argument that's trying to be developed. But somehow it's being said that it's okay, like it's just the hijab, but it's not. It's everything in reality. And I think that's also a huge problem. And I think another thing I was thinking that what I personally feel why this ERP argument was taken first was because because at some level it's easier to convince judges that, my religion triumphs the school or the community as a whole. An individual right, it's great to argue, and we want that individual right to develop. But sometimes judges don't buy it. Judges just feel that it's easier to go to the religion route. I think that's also why this argument could have been taken, but we are not sure why the strategy was adopted.
Like optically, for the court, it's easier to justify striking down state regulation on the basis that an entire religious practice is
Yeah.
against it, as opposed to saying that this one individual's belief, contravenes the state regulation. So it's just it looks better for the judges as
It
well.
looks better. It looks better for the public and the media. But we want that individual rights and a right weight. But see, that's what we keep on discussing this podcast, that we want something from the courts, but a lot of times the courts don't want to give it.
Yeah. I guess that maybe we can spend the last couple of minutes talking a little bit about the fact that this case was live streamed, and it's probably one of the first high-profile constitutional cases in India to be live streamed. So, as somebody who's been like involved with the case, tracking it closely, could you tell us whether one, you think it's impacted the arguments, both in terms of the judge's behavior and the lawyer's behavior, and two, anything else that you have noticed being involved in a case that's being live streamed that's different from, say, other cases?
Right. So in terms of the judicial behavior, I think I'm somewhat of having limitations to speak about that, being personally involved with the case. But of course, live streaming in general has been quite revolutionary, I think, especially I think in constitutional cases of this nature. It's great that the live streaming proceedings are going on and people are able to watch it, at their liberty, at whenever they want. And it's exciting to see both students of constitutional law or law students from different colleges and academics and teachers, and everybody is able to sort of have, look at what is actually happening in constitutional courts. And I mean, there is never an argument, I think, against live streaming. I fail to understand why the Supreme Court and the other high courts are in fact delaying the process of live streaming, although the Supreme Court has held already in the Rajay Singh's case that court proceedings must be telecast live. So that is, of course, a welcome step, and that's been quite promising, and I think a really great example for other high courts and, of course, the Supreme Court to emulate.
But so I have one contrary opinion to live, like, even though I believe live streaming should be there, but one contrary opinion usually is that courts, while an argument is going on, a lot of things happen that are not necessarily required for people to be seen, right? Because lawyers sometimes knows much more the context of things happening, and a lot of things that are actually should not be said publicly, or you should be called out for, or said in courts, but they are given a go by because A, that doesn't impact the case. B, the lawyers don't want to call out these things because they want to win the case. So they don't believe that we should get into these unnecessary questions of what is right, what is wrong, if it's not impacting the case. But once it's being live streamed, a lot of things are in the open. So sometimes I feel it also, like, obviously it impacts the lawyers and the judges, because now everybody wants to be on the live stream, right? That's a great, and it's human nature. It's not like somebody is wrong or like correct, but that's how humans work. Everybody wants to be on it, and they want to look right in front of the public because now everybody is watching. So I think 17,000 people roughly watched this live stream, and that's a massive number to have. I think that's also a huge thing.
Yeah, that is true. I mean, of course, there are a lot of things like in confidential cases. Of course, there are reasons as to why certain proceedings should not be live streamed in case of sexual assault, or in cases where very sensitive information is being told, or when the examination of the witnesses happen or of the victim happens in sensitive cases. Of course, there are good reasons why we should not allow live streaming that directly has impact on the privacy and dignity of the individuals who are involved. But I think that as far as the Karnataka case is concerned, it's a constitutional case, and there is much less to do with privileged conversations between the clients and the lawyers. It is much less to do with sensitive information. Of course, it's somewhat impactful of what strategy lawyers want to adopt in cases. And of course, it's being seen by everyone. But I think that's sort of a necessary evil that we have to put up with, because we have to choose one of the two. And I think it's better to opt for transparency when when we have that.
I think one more thing is that the government keeps on requesting that it should not be live streamed. I think initially they said that elections are going on, should not be live streamed, and then the judges with the opinion, how does it matter? Like, the elections are happening in some other state. Who are you to object it? And then today also, before the argument started, the AG requested that the live streaming should be stopped. So that tells you that who doesn't want live streaming to be there. And that's also very.
I think there was also one of the petitioners council who argued that the live streaming should be stopped, if I remember correctly. So I think both sides are a little bit nervous of this entire issue.
I think on this the opinion is split. I think some people among the petitioners do think it should be, and it's vice versa as well. So
One last thing I wanted to ask you is, a lot of non-lawyers who aren't or who have never been inside courts, like when they watched it, I got a couple of texts saying that, is it always the case that it's all men who are arguing these big constitutional cases? And watching the live stream, you can't help but notice that there is a significant paucity of gender equality across both the bar and the bench.
So I was wondering, 2 women involved in this case. One is with us and one's the judge. So that's it. You can come, like, of who are arguing. There would be like associates and like people who are assisting, but you don't see them. So they are like the faceless people of the court. But that's it. And that's a huge problem. I think that's what Vasu and I were discussing, that, what's happening in this case.
Yeah, so I was just wondering whether based on your experience, if that's reflective of the general trend in constitutional cases and other litigation in India, and what your thoughts were on it.
I mean, of course, there's a huge problem of representation, and I think a lot of women lawyers have spoken about it whenever they were allowed to speak about it. So, I mean, it is true that the litigation space is very, very centered on men, and there are, of course, problems that women face both inside and outside court. So the idea is to increase, make the court and generally workplace a safer place for women, and sort of encourage and take steps to empower women in the respective ways, in whichever way the system can of course steer that development. And it's true that, even when we look at the judge strength, generally speaking, in the Supreme Court or high courts across the country, we see that it's a very, very few women who actually get to be part of the bench. And even among senior lawyers, or even among lawyers generally speaking, people who actually get to argue, there is a very, very low proportion of women. So that's indeed a problem that we need systemic solutions for.
Yeah, I think that's a wrap from my end, unless Rishabh, you have anything else. Tulsi, you have anything else you'd like to add?
No, nothing in particular. There are, of course, like a couple of other issues with the hijab ban as well, but I don't know if we have time to get to that. So, of course, issues of freedom of expression, there are, of course, freedom of association, and we also need to think about what good is being denied to the Muslim women on account of the hijab ban. We need to think about how important is education as a cultural capital, and what exactly is taken away from them. I think that's quite important for us to look at. So there are these issues, but perhaps we can talk about that another time.
Yeah, so I think we've decided on a next episode also. So I think we can do it at that of time.
We can have you back on to do a deep dive into these secondary arguments now.
Thank you. Okay. Thank you so much.
Thanks so much
for joining us.